surgery which is appear in the list, your lordship, we take adjournments for the service not affected.
What are the matters relating
It is
to?
a matter about the incident writ petition has been filed being agreed by the action of the Kuchbiar municipality, who is not allowing the petitioner to display the advertisement in spite of the subsisting agreement. Whereas the advertisement.
Next Tuesday. Three matters are concerning same issue.
Your lordship.
May it please,
Sub
your
to-
may it please your lordship. I seek your kind indulgence in three matters which I'm listed, which I'm going to say this morning, if permitted, I may say. Writ petition application 367 of 2024. This instant petition lacks territorial jurisdiction, and accordingly, I seek liberty to withdraw this matter. And in the interest of the judicial propriety and to avoid complicity in the multiplicity of the proceedings, I would request, humbly pray that the matter be listed in the heading appropriate as to enable such withdrawal, sir. And the
You
next,
want to withdraw the matter?
yes, Your Lordship.
Writ petition of 2024.
Yes, Your Lordship.
Have you served notice upon other side?
Yes, sir. The jurisdiction is Patna. It has been, the notice have been served.
Tomorrow to be mentioned.
The next one is, sir, writ petition application number.
Withdrawal.
No, this is another one. Affidavit in opposition, number 1237 of.
An opposition order has been passed.
Yes, Your
We
Lordship.
will not consider now. See, hearing matter.
So,
2025, the lordship. So this was taken up on 8th of July and it was fixed for further consideration and then the direction was passed to fix for 10,
Relating to,
relating to lordship. It was
wait for some time. There are matters, please.
My lords, order was passed yesterday. Inadvertently, the names of the council of both the sides have been mistakenly written.
Yes.
Name of the council in the orders, and both the sides have been mistakenly written, wrongly mentioned. ma'am.
Some others council names are there. Tomorrow to be mentioned. For correction.
Lordship, may I permit you to mention the matter? Lordship, this matter, the petitioner is jobless since 2 years. Lordship, there is a direction for the opposition, Lordship. If your Lordship takes the matter in the list, Lordship, the state will.
I am not in a
only-
position, see the position after completing the
State will
motion.
file the opposition.
Sorry,
For extension of it.
when expiring?
31st of this.
Permit to mention.
31st?
Of this month. It's 31st July.
Lordship, may I permit to mention.
Serve notice upon other.
For inclusion in the list, Lordship, as an application, Lordship, I pray for interim order as an application file.
Application for interim order you are praying for.
Yes, Lordship.
Monday, serve notice upon answer. All the note. Why at least there is less attendance today?
Some confusion may be there regarding the.
Oh, there's a resolution.
Not exactly, my lord, there is a resolution for not to pass any adverse order. As
No,
yet.
not to pass any order in absence of any other. party.
Yes, your lordship.
Yes, call the list.
My lord, I am applying for the petitioner. My lord, this matter, my lord.
Yes.
My lord, this is a matter, my lord, where it is running in your lordship's list as hearing matter. Now, my lord, what happened? Lordship, kindly see the last order.
There's a requisition come from the.
Yes,
principal.
yes. I filed a contempt application. I mentioned this matter before His Lordship Honorable Justice Vishwajit Batu. Therefore, the requisition has come because there is a gross violation of His Lordship's order. That is, my lord, 4th of December 2024.
Then what happened? Who directed?
Court
matter to
sent,
appear?
court accepted and the requisition has
এই
come.
এটা অর্ডার ছিল দেখিয়েছিল কালকে প্রিন্সিপাল বেঞ্চ থেকে এসছে একটা অর্ডার না একটা ফুট আছে এটা তো আমায় দেখতে হবে নাহলে আমি ছাড়বো করতে দিব সামনে মাতৃগান রেকর্ড
আমার মেনশনে আসবে কেন?
there has to be something on রেকর্ডে থাকতে হবে নাহলে আমি রিলিজ করবো করতে গেলে Where is that? It has to be on, on the record. Wait for some time.
Yes, your lordship.
Call the next matter.
Item number 2. Lord, I for the petition, Lord, laid by Devastik Banerjee.
My lord, in item number 2, my lord, I beg to appear for the petitioner, my lord.
Yes.
My lord, the petitioner is an
All parties
assistant.
are present?
Yes.
What about respond number 15, 14? Management of the school?
Yes, your,
15?
yes, your lordship.
Officer in charge, Mukshidhat.
For unprotested.
Service Commission. School Service Commission, who is appearing? Not today.
Well, they have to take the time.
Next.
My lord, school service commission, my lord, is not a necessary party.
When
Answer
you will come back
party-
tomorrow, there is a resolution that if all the parties are not present.
My lord.
Yes.
But item number 3, my lord, I appear for the petitioner, my lord.
Well, we are for the.
My lord, this matter was taken up yesterday.
Yes.
There's a private respondent, my lord. Private respondent most probably served, my lord. This relates to my lord and proceedings.
Private respondents we presented today. Not today, Monday, on Monday.
My lord, grateful.
Next.
My lords, I appear for the petitioner in item number 4.
I am for the respondent, lordship.
This is a GST case. I am coming after appeal. Very
Then
small
scope
issue
for
is
passing
involved.
the interim order. If the order of the appellate authority is under challenge, what is the scope?
Affidavit may be called for, my lords, but
Yes, what do you want to submit?
this issue is covered by the Supreme Court decision.
Yes. Because now the rectification is sub judice before the Supreme Court. So,
It is not sub judice. Sorry.
now, for the, under consideration.
I will share the judgments also. What happened, my lords? I'll tell you.
So
In
therefore,
brief.
you want that the matter to be, matter should wait till the order comes from, the
Yes.
final decision comes from the Supreme.
There is one similar order passed
Well,
by
exchange
coordinate
your
bench.
affidavits, what is the order?
Oh, very well, my lords. The impugned order is at page number 80. Page 80 to 87 is the impugned order. Operative part is at 86.
Page 82.
80, 8080 to
It's a
80,
communication letter.
starts from, my lords, 84.
It is ordered dated 5th September 2024.
Uh,
What is the date of order?
Yes, my lords.
592.
5/9/2024,
5th September 2024.
yes. And operative part, my lords, will
Passed
speak.
by the additional commissioner.
Yes,
Appellate authority.
Appellate
Appeal
authority.
under section 107.
yes,
Lords.
Issue. File your affidavit service.
very well. Okay. My lord,
Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. In the writ petition order dated 5th September 2024, passed by the appellate authority under section 107 of CGST, SGST Act.
it's pari materia, my lords. This is CGST.
No, it's CGST.
CGST.
This is CGST.
Put a CGST Act.
They go there.
Give me the nomenclature of that.
Judgment.
দেখবি একটা হলদির রঙের বইটা আমার ওখানে ছিল, কোথায় গেল পাচ্ছি না কেন
হ্যাঁ, ওখান থেকে-
এখানে অত থাকে না।
কিতাব তো হ্যাঁ।
What is this? আর নেই, এখানে নেই, আমি দেখলেই বুঝতে পারবো। হ্যাঁ, কি বলছিলেন বলো তো? Central Goods and Services Tax Act 2017 is questioned. Stop. Next paragraph, on perusal of the order, it appears that the issue needs to be decided on exchange of affidavits. Next paragraph, like affidavit in opposition to the petition be filed by 4 weeks from this. Affidavit in reply thereto can be filed by 3 weeks thereafter. Next paragraph, petitioner, party shall be at liberty to mention, party shall be at liberty to mention the matter before the, next available circuit after the time fixed here in above for exchanging affidavits.
Grateful.
Exchange your affidavit. In the meantime, if order comes from the Supreme Court.
Great.
Yes, call the Passover matter. এটার সঙ্গে ট্যাগ করে রেখে দেবে। উইদাউট দিস আমি এটা করবো না কিছু। এটা এখানে ট্যাগ করে রাখবো। Now, it's an interim order. Contempt is.
Yes, interim order in.
Even final order, main order doesn't, interim order doesn't remain.
My lord, interim order is there.
Or in the, if the final order is passed on this writ petition, then the interim order merges with the final order.
My lord,
And
what
matter is running in the list.
matter is running.
You
in
should
the
have brought it to the
My
notice of
lord,
the court.
my lord, yes, your lordship, in the earlier circuit.
Have you
law-
brought it to the notice of the court? Where is the indication in the order passed? by
My
the
lord,
court?
what happened, lordship, in the earlier occasion, in the earlier circuit, Honorable Justice, I mentioned before the Honorable Court, the Honorable Court, my lord, directed me that since it's a violations of the order of His Lordship Honorable Justice Vishwajit Basu, therefore,
Violation remains violation, but this color gets changed. If final order is passed and the interim order then merges with the final order.
my lord, that is true, but since,
Then-
my lord, it mattered.
So have you brought it to the notice of the court that the matter is appearing, running in the list?
No, that I not,
Then
my,
Why? Why? not?
that, because, my lord, my simple.
You should have
sub-
brought it to the
My
notice
lord,
of the
my
court.
my lord, this matter is pending as a hearing. There is a direction for exchange of affidavits. The Mal municipality has not yet, my lord, filed any affidavit. My lord, therefore, my lord, I mentioned this matter before the earlier
Yes, sir.
honorable bench. My lord, he suggested me to file a contempt application, lordship.
But it needs to be brought to the notice of the court. Who is insisting of the contempt, which is insisting of the contempt application.
My lord, that I.
That the matter is running in.
No, lordship, my lord, candidly speaking, my lord, that I didn't,
Then-
my lord, say, my lord. But since it's a violations of his honorable justice order,
আজকে কত নম্বর আইটেম আছে গো? গতকাল লিস্টে কত নম্বরে ছিল? দেখো। Record note. Matter has come up in the list under the heading to be mentioned, quote unquote to be mentioned. Since it has been brought to the notice of this court by the registry, that a letter has been forwarded by the assistant registrar Roman 15 in charge, dated 23rd July 2025, whereby Deputy Registrar within bracket administration circuit bench circuit bench of Calcutta High Court at Jalpaiguri was requested to transmit the record of this writ petition to the principal bench. Next paragraph. Matter was running in the list at serial number 147. under the heading hearing, or for hearing, quote unquote, under the heading for hearing in the daily cost list dated 23rd July 2025. Next paragraph. Since it is intimated by the Assistant Register 15 in charge, read a letter dated 23rd June, since the paragraph, since it is intimated by the Assistant Register by the Assistant Register 15, Roman 15 in charge, read a letter dated 23rd July 2015. That a requisition was forwarded by the court of the coordinate bench. The writ petition let the writ petition be delisted and records of the writ petition be immediately forwarded to the principal bench for taking necessary steps. এটার সঙ্গে ট্যাগ করে দেবে, এটাও এটার সঙ্গে ট্যাগ করে দেবে।
Gratefully, Your Lordship.
Next.
May I please your lordship, my lord? I apologize to appear virtually, my lord. I beg to appear for the petitioner, my lord.
All parties are present.
My lord,
I am here, my lord. My junior is also there, my lord, in court for the state respondents.
my lord, my main answering respondent is the state only, my lord.
I am asking you, all the parties are present.
My lord, we have already served on all the parties, my lord.
Not today. Next.
I am for the respondent, Lordship.
My lord, I am for the petitioner, madam.
Yes.
My lord, my company is one of the oldest and reputed colonial heritage hotel in the Eastern India. So the crux of this petition is, my lord, that I have been initiated with parallel proceedings under CGST Act 2017, that is both audit and scrutiny, my lord. First of all, this does not, my lord, is not sustainable under law, as far as it does not fall under the statutory provisions of the GST Act as well, my lord. Now, on 30/9/2024, I received a intimation notice for the audit, my lord. Subsequently, I received 2 more notices, which were by mistaken.
What are those two parallel proceedings?
My lord, it's audit and audit under section 65 and scrutiny under section 61.
Both proceedings are continuing.
Both proceedings are continuing.
Where is the bar?
My lord, audit is a bigger perspective, where
Audit is?
is a bigger perspective where all my audit accounts are, all my documents are looked into for further taking out mistakes, whereas scrutiny relates to only checking of the returns of my company, my lord. So audit has a better perspective, and it has more bigger scope.
Scrutiny, audit has a wider connotation.
Wider
whereas
scope.
Scrutiny
Has a
is only restricted to the scrutiny of the
returns, my lord, returns of the company. So, my lord, on 30/9/2024, I received first audit notice regarding conducting of audit for the year 2018-19 to 2021-22, my lord. Now, this notice,
When you received a scrutiny notice?
my lord, I received 3 notices on 30/9/2024. 30. Then
Now,
I
have you participated in both the proceedings?
my lord, I'll come to that. My lord,
Have you participated in both the proceedings?
my lord, I have participated in the audit proceedings.
In scrutiny proceedings, you have
Scrutiny proceedings, my lord, I didn't receive any notice directly. The demand came on 22/5/2025. Now, my lord, what happened after receiving 3 multiple notices which went unnoticed by our company due to certain irregularities within the company's internal structure, we received a show cause notice on 6/3,
In
2025
connection with scrutiny.
in connection with audit, my lord.
Audit.
In connection with audit under section 122, subsection 1, clause 17
Of
GST Act, my lord.
central.
Yes, my lord.
Yes,
My lord, may I?
yes, yes.
Because audit was initiated, the 3 notices were given to them. It is, they have mentioned in.
In connection with audit, school,
Audit.
audit.
The 3 opportunities given, they have not appeared. And after that, because the once they have not appeared, so there is the provisions that we have to forward this thing for the adjudication. So for the adjudication under 61, the notice for the scrutiny is being issued. So now there is no audit, only we are continuing with the section 61 scrutiny proceeding of the notices that.
So
is
you have
not-
abandoned audit proceedings?
Yes,
So then a court can record it that audit proceedings has been abandoned.
yes.
My lord, we have not received any communication. My lord, can I
Because
show
they
it?
come before giving the.
Listen, my lord,
time.
we have
They
not
have
received any,
submitted.
we have not received any communication, my lord, according to section 65.
So you don't want to even participate in the scrutiny proceedings?
No, my lord, we want to
So
participate.
participate and come back.
Yes, my
Audit
lord.
proceedings is, they are submitting that they will not proceed with the audit.
Yes, my lord, but we
My
have not,
friends.
we have not received any communication regarding the same.
They
Yeah,
will-
No, my lord, may I, my lord, as my 2 juniors are there, my lord, that's why I did not interfere, my lord. When my learned friend, Mr. Agarwal already said, they do not want to intend to proceed with the, my lord, the audit proceeding. It doesn't remain, my lord, anything. So scrutiny will participate, no problem, my lord. Whatever the records we will transmit. And in view of the, my lord, the order of the honorable, my lord, this coordinate bench by the honorable Chief Justice, my lord, if a lordship seat has been annexed, the 2 parallel proceedings cannot be sustained, my lord.
No,
But here
Central GST authority is saying that
Yes.
they have abandoned scrutiny proceedings.
Yes, they have
So
no other.
therefore the audit proceedings. Now only the scrutiny in connection with scrutiny, petitioner's company is required to appear before the authority.
Only
Yes,
for
my lord,
1
yes.
year. Earlier, the audit was for 4 years. Now they have not participated. So as per the provisions, we have to take one step. So it is forwarded to the adjudication. Audit is not the adjudication, only the verification of the records. So now that is being concluded. Concluded means it stopped.
Not
Audit.
concluded, they didn't participate in audit.
So that's why
They didn't participate in
so
audit.
we have to take the another recourse. So that is under 61. Only for 1 year.
61 is
Scrutiny of return. Scrutiny of whatever available in the portal. So that we will only for 1 year. And moreover, kindly see this page 43. Now they are in the better position. Earlier they are having the 4 years.
audit.
Yes. Now we are only pursuing for 1 year. And
No
that-
problem. It's not a question of better position. We have submitted all the documents pertaining to.
Are you appearing for the petitioner?
Milord. Central.
Kindly see 43 lordship.
Central, Milord, some privilege, Milord, in appearing for the petition.
But the state is a party, Mr. Chaudhary.
It is the party.
No, it's a
You are not appearing. I thought you were appearing for the state.
By my 2 juniors, Milord, I have, because they are so, Milord, vast.
So lordship, whatever their prayers, I have not understand what is their prayer.
Return for 1 year only. So why audit proceeding was abandoned?
After particular, because in the provinces, in the notices that you are why not the permit, and if they are failure, there is a provision to impose the penalty.
Mr. Agarwal, your microphone is switched off. I cannot hear you.
They have replied also that it should not be leave it. So department will take care of it, and page 43 kindly see lots of the writ petitions. They have filed all the things.
So they are submitted that they are submitted before the jurisdiction.
Yes, they have only filed only.
In connection with the show cause notice, in connection with scrutiny proceeding.
Scrutiny audit, everything they have submitted on 9th June 2025.
Just
Kindly see the repercussions.
Now, in connection with scrutiny, any notice has been issued?
Yes, yes.
Where is that?
My lord, page number 19, the writ petition.
Page number?
19. my lord.
91.
19.
Now, in pursuant to this notice dated 22nd May 2025, they have
Appeared.
They appeared.
They have kindly see page 43.
Page 43.
Regarding audit. My lord, may I?
Wait.
Last communication the यही है.
Whether any date to date by which
Lordship, this is the last
reply has
communication.
been submitted, 6 June. On 9 June, reply was submitted beyond the date.
Yes. Actually, 22/5 in the May, proceeding under 61 is initiated. After that, they have filed the reply. Complying, they are saying that we are filing all the document with regard to the audit. So now there is no audit because I have taken the instruction. Because the process is that once they have not complied the audit, all the notices, only the penalty were issued. So they have also, that is also they have replied, it is under the consideration whether
That is in connection with audit.
audit. Because they have not complied, the failure to comply in the, all the taxation.
Penalty
regime,
order
there is
was
a penalty is there, the small penalty, whatever. So that is under the consideration, let them decide. And now the 61 proceedings will be there.
Yes.
That is
My
what
lord,
here.
according to what my learned sir has been telling me, that audit has been, we have received no communications regarding the conclusion of the audit. My lord, kindly section 65 of the.
But just
CGT
now you have submitted that you have abandoned the audit proceeding.
Right.
So where is the question comes relating to penalty?
Now, penalty in, before initiating 61 proceedings, 3 notices were issued. That why you are not complying with the audit proceeding. For that, there will be levy of 10,000 rupees. Why it should be imposed? So they have replied also.
That is in connection with audit proceedings or?
Audit.
Audit.
Right. They are saying that they have also referred to the some of the judgments also, that it is a.
So, but no final order has been passed.
No, no.
So at this stage, what is the scope of interfering by this court?
My lord, we had no.
Because there was a notice relating to audit. You did not comply with the notice.
Yes, my lord.
So
we did
that
comply.
culminating an or penalty order.
We are,
Now that if for which a show cause notice has been issued.
yes, my lord.
Before imposition of penalty.
Yes, my lord.
This is the position so far audit proceeding is concerned.
Yes, my lord.
So far proceeding under section 61, a notice has been issued on 22nd May 2025.
Yes, my lord.
Which has been responded to by a letter dated 9 June.
No, my lord.
9
No,
May
that-
2025.
That letter is regarding
No,
the
no,
audit
my lord.
proceeding.
My lord, may I clarify, my lord? May I?
They have not responded this notice. This 61 notice, they have not responded till date.
Yes, this is the reason, my lord, we have challenged. Two separate proceedings cannot be initiated. This is the reason, my lord, we have invoked the jurisdiction of this honorable court, my lord.
What's if there is no two parallel proceedings?
Then
Because
they
the
haven't
parallel-
disclosed as of now. Now they are saying you have abandoned. How
Yes,
will
Because the ambit of these two proceedings are different.
Yes.
Yes, my lord.
Because this is that these two proceedings are not overlapping each other.
Yes.
This is your contention.
This is also the contention. And the first contention is that if they have appeared in the audit, it was already finalized. So there is no question of 61. Because they have not complied, the audit notices, there is a lapse of time. So there is so we have to take the another recourse. So we have taken.
No, why? That audit should be brought to the logical conclusion.
Exactly.
No.
Irrespective of.
Actually, if somebody,
You take steps in audit proceedings. If you submit that you are abandoning audit proceedings, then court will permit you to go ahead with the scrutiny proceeding.
Yeah, definitely, we have abandoned it.
So say so. Why you are
No,
why you are blowing hot and cold? One you are saying once you are saying we are abandoning it. Subsequently you are saying no, a penalty order has been passed. That will not permit. That will not be permitted.
penalty order is passed before 61 also. Before conclusion, before.
Abandoning audit, court will record that abandoning audit proceedings.
Yes,
You will resort to this scrutiny procedure.
Correct. That is the.
kindly record it, my lord.
Yes. Because two parallel proceedings, why this will do two parallel proceedings? Once you have decided to initiate audit proceedings, let the audit proceedings be brought to logical conclusion. Otherwise, discard that proceedings, initiate separate proceedings. Then court can understand your stand.
We have discarded the audit proceedings. Now 61 is only.
A dubious stand should not be taken against before the court.
No, if they have not complied,
So,
not complied with the audit, then it's all right. The judgment, what they are referred, because in that case,
affidavit of service filed.
Yes.
Affidavit of service filed on behalf of the affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. The grievance which is expressed on behalf of the petitioner is initiation of two simultaneous proceedings. One is audit and another is scrutiny. Audit is under which section?
65, my lord.
One is audit.
One is-
Under audit under section 65 of the Central Goods and Services Tax Act 2017. Within bracket hereinafter referred to as the said Act of 2017, close bracket. And another is scrutiny under section 61 of the said Act of 2017. Stop. It is submitted that as per settled position of law, both the proceedings cannot run simultaneously by the CGST authorities, authorities. Stop. Next paragraph. In answer to the in reply to the submissions made on behalf of the petitioner, it is submitted by the learned advocate representing CGST authority that first audit proceeding was initiated under section 65, where petitioner did not participate. did not participate,
My lord, we participate, but after the lapse of the time.
where petitioner did not participate within the specified time. As a result, where petitioner did not participate within specified time. As a result whereof, concerned CGST authority has decided to initiate scrutiny proceeding as contemplated under section 61 of the said Act of 2017. Stop. It is also brought to the notice of this court that a notice relating to a proceeding under section 61 has been issued on 22nd May 2025. Stop. It is also submitted that it is also submitted since petitioner did not participate in audit proceedings, abandoning such proceeding, concerned CGST authority has decided to initiate scrutiny proceeding. Stop. Next paragraph. In view of the submissions, in view of aforesaid submission made on behalf of CGST authority, it appears at present only scrutiny proceeding is pending against the petitioner, and audit proceeding has been abandoned. Stop. Therefore, the apprehension which has been expressed on behalf of the petitioner that two parallel proceedings are subsisting as on date is not found to be substantiated or is not found to be correct. Stop. Next paragraph. In view of the respective submissions made on behalf of the parties, court is not required to address the issue whether concerned CGST authority is authorized to run two parallel proceedings or not. Stop. Since at present only concerned authority of CGST, concerned CGST authority is contemplating to conclude scrutiny proceedings in terms of section 61. Leave is granted to the said authority to conclude the scrutiny proceedings in accordance with law after granting opportunity of making deliberation to the petitioner. Stop. Next paragraph. With the aforesaid observations, petition stands disposed of.
My lord,
my one more submission, my lord. Already we have participated in the, my lord, the audit proceeding. Kindly, my lord, indicate.
No.
Yes.
You did not participate within the specified time, Mr.
After
Chaudhary.
that, my lord, when the
That is what I have recorded. That petitioner did not participate within the specified time.
but later on we have participated, my lord.
That doesn't make any difference.
My lord, there.
Next matter.
My lord, one request, my lord.
Sorry. All parties are present.
Yes, ma'am. This was taken up before by my lordship, my lords. The only issue remaining here is the payment that has to be done by the project director of the National Highways.
এই অমিত ওইটা নিয়ে নিস কোনো অসুবিধা হবে Yes.
Lords,
Yes, what is your
to start the hearing? No.
of the supplementary affidavit. For disposal of the application is not, need not enter into, read the entire order without entering into the merit of the claim. Petitioner is the petition is disposed of by directing project director, National Highway Authority of India project to consider the application of the petitioner.
That way, I have not got the lordship. Now, I will just request my service and they have given me work. Next day, lordship, page number 86. I have mentioned this matter for rectification of the order.
Yes.
Then the petitioner opposed and the order means the same, the rectification of the petitioner considered by the National Highway Authority. That means the National Highway Authority is the accident respondent here, or it should be considered a petition of the petitioner lordship. In the meantime, we don't understand why the FADA has submitted the estimate lordship.
Why?
Now, why the FADA has submitted estimate.
Kala means?
Competent. The special acquisition of it's short lottery FADA.
When you are before the court, please don't use this sort of abbreviation. Yes. We are not having a conversation with your department. Yes. Yes, yes.
But the answer to that is in page
Just a
29.
minute, allow her.
Malsh.
Allow.
Malsh.
No, it was directed by the coordinate bench that the appropriate authority of the National Highway Authority to take decision. Yes. Now in the subsequent order passed by the coordinate bench, whether any modification order was passed. So project director, National Highway Authority, National Highways Authority to take decision. Now thereafter what happened? Yes, this is the decision.
What the has suppressed lordship, the award was declared the year 2015 lordship. This petitioner was participated in the arbitration. Subsequently, this petitioner was challenged this award before the district under section 34 lordship. The order is 34 application was dismissed lordship by the copy of the 34 application, and after 9 years of arbitration, he has come with an application to revive his case lordship. This 37 section 37 already goes up to the year of 2021.
But then you have passed an order on 24 June 2025. Claim. Let it be decided on affidavit.
That might not be required.
No. You have taken out a different recourse.
No, my lords. At page 29, the first contention was why did the Kala prepare the state estimate? Kala has been referred to.
You have initiated a separate proceedings. Failing, then you are coming before the.
No, my lords. As what happens as per the National Highways Act is there is a determination, and in furtherance to a determination there is an arbitration that happens.
Yes.
If there is a
There's
fresh
arbitration
determination,
clause.
if there is a fresh determination, page 29 for a moment, last line, my lords. Page 29, they asked the special land acquisition officer to give fresh estimate. So there is a fresh determination. If they are aggrieved, they will go in arbitration. Why? We are not aggrieved by this.
But you have gone to gone for arbitration.
That was only in respect of the market value of the land, not in respect of the interest. That is a different determination. This is a different determination. My lord, can I have a look at the arbitral award?
What was the final order passed in the arbitration?
In the arbitral award, the market value of the land was increased to a little bit stand. That is what that was done there. At that
Show me the order. Passed
she
in the arbitration.
has handed over a copy of the arbitral award to my lordship.
Application. Award. Oh, that arbitral award was challenged to
challenged.
the district judge under section 34.
Only the,
And that was rejected.
Yes.
Very well, but confirming the arbitral award,
the market value.
confirming the arbitral award.
Yes.
So if arbitral award was confirmed, where is the order arbitral award? Bring the arbitral award.
Will bring the arbitral award.
He is correct. If today,
The
where is the-
arbitral award was only some.
where is the difficulty?
circumscribed
If
to-
court proceeds on the basis of arbitral award. Taking note of the arbitral award if court proceeds. Arbitral award was confirmed by the district judge by dismissing section 34 application. Now, if section 34 application has been dismissed confirming the arbitral award, then the what is there in the arbitral award that should be taken into consideration.
Yes.
And appropriate orders to be passed.
Was paid not that logic and the what he said in page number 28 or 29 is logic. The project director asked for the 3G estimate if any payment is pending, 3G estimate, not any enhanced payment or nothing. Can you read the page number, may I read something? Page 29 document.
Because the very fact that they have asked for the estimate suggests that it was not covered in the arbitral award.
Page 29.
Last line, my lords.
Just.
This is the project director writing to the special land acquisition officer.
Just. Then why your DGM, Deputy General Manager, wrote to Land Acquisition Officer that if
Process
any amount is payable?
Yes. But as per our knowledge, in by year 2030, we have paid the entire compensation.
Then
Just
where is the meaning of the last paragraph?
if any-
What is the meaning of last paragraph?
if
If any amount is payable to the applicant, she Shopon thus is still due.
3G,
The estimate of the same may please be submitted to this office at the earliest.
yes, other 3G. 3G was already submitted by the government.
Is there any quarrel in between this claim of the petitioner and the final arbitral award?
Yes, Lordship. If I can have my lordship for a moment on page 23, the representation that
There is
is
the final arbitral award.
the arbitral award we will produce, it was only in respect of the market value of the land, nothing more than that.
Produce it.
We will do that.
Produce. Not today,
Not today.
next Tuesday. Matter is heard in presence of the learned advocates representing the parties. Learned advocate representing the petitioner has prayed for accommodation to produce the arbitral award. Stop. List the matter under the same heading for further consideration.
That might not be required.
Let me consider it on the next date in the context of arbitral award. How far it is different so far the case made out in this petition on 29 July 2025.
Deeply august.
Admitted amount has already been paid.
Yes.
Now you want that
Actually, the composition of the compensation is there are 5 different components. One is a market value, there are trees, there are structure, there is interest, and there is solution. This interest component was never paid. It was never part of the 3G estimate. So whatever arbitral award is there, that is only in respect of the market value of the land, nothing more than that. Even the structure and the trees were not paid at that point of time.
So that payments you are seeking.
It's still due, and we are seeking that payment, and they have sent the estimate. Now the National Highway needs to pay it. How can there be an arbitration before a determination? How can there be an arbitration before determination? The determination has to be first.
Next matter.
My lordship.
Very, very. Let me consider it.
Lordship,
Not today.
Lordship, in this matter, I am appearing for the
Other
petition.
side is not there, not today. There's a resolution. Yes, next.
Lordship, in that case, can it be possible to make on Monday?
Very well.
I appear on behalf of the petitioner, my lord.
Very well. On Monday, আগের যেটা কত টাকলে যেটা
April.
appear করছে
Lordship,
Monday, adjourn till Monday করে দাও. Yes. Next.
My affidavit of service.
Who is for the other side? Not today.
Next month.
Not today.
I don't know, I am for the petitioner.
Yes, who is for the respondent?
State.
I'm for the private respondent.
State. Not today. Next. All parties are present today?
Yes, my lord.
There is no private party.
Yes, I'm looking for the private.
I know my affidavit.
But this is a writ petition that was been heard. This is the third round of litigation.
What you are challenging?
My lord, the opposite party, private opposite party, are running a nursing home in an unauthorized construction, unauthorizedly constructed building, my lord. There are severe deviation from the facts that the inspection was conducted on several occasions, my lord.
So you are challenging 20th May 2025 order.
My lord,
Where is
based on
that
that order passed by the Honorable Court,
Where is that order?
my lord, that is at
P7, page number 231.
231.
31.
And this order was passed after 1 year when the contempt application was taken up. On that day, the order was passed. To avoid the contempt,
Who are you?
I am an resident of the same premises, my lord. I am
Owner of the premises.
no, my lord. I am an owner of a part of the premises in the ground floor. The
Now the nursing home is being run by an
Private respondent.
private respondent,
in
and
the-
that part is owned by whom?
that part, my lord, they have purchased the first floor and they have raised illegal construction after purchase second and third floor. Now, my lord, when they have purchased the property, the plan had expired. After the expiry of the plan, no valid plan was obtained by them, and then they have raised the construction, my lord. Now, my lord, the impugned order suffers because, my
Just a
lord, they are in hand in glove with the private opposite parties, my lord. The corporation is acting hand in glove, my lord.
না না বসো, তোমার সাথে কথা আছে। ডিকটেশনের জন্য যাই, বসো। So already steps have been taken and they are
No, my
directing
lord.
the nursing authority to stop the first floor.
Only first
Second floor, immediately stop the unauthorized use of second floor of the said building, since it is a residential building which is being used as a commercial purpose. There is a change of user.
My lord, there is
That
two
is
part
taken
to
care of by
this,
the-
my lord.
By the corporation.
The corporation,
In addition to that, what do you want?
my lord, they have not considered the entire case, my lord. That is my argument. My lord, what they are doing, my lord, they have purchased.
Precisely, what do you want?
My lord, I want the
Demolition?
building because, my lord, the entire first floor, second floor, third floor is unauthorized. There are deviations, there is open space violations, and my lord, what they have.
In the writ petition, order dated 20th May 2025 is under challenge. Whereby file your affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. In the writ petition order dated 20 May 2025, passed by the Commissioner, Siliguri Municipal Corporation is under challenge. Whereby whereby private respondents, opposite parties are private respondents.
Yes, my lord.
Whereby opposite parties were directed to immediately stop unauthorized use of the second floor of the said building.
And yet they are using it also, my lord.
Directed immediately stop the unauthorized use of the second floor of the premises in question as nursing home, since it was found that the premises in question is meant for residential purposes. Stop. Next paragraph, land advocate representing with the petitioner submits that there are unauthorized constructions.
There is.
There is unauthorized construction in the premises in question, which has not been addressed.
But they have regularized it by this order.
Which has not been appropriately addressed. Yes. With a impugned memo dated 20 May 2025. And such unauthorized construction has been regularized.
Unlawful.
Stop. Next paragraph, land advocate representing private respondent has submitted that they have private respondent has submitted, land advocate representing private respondent has submitted that private respondent or respondent, private respondents, private respondents, that private respondents have complied with the order dated 20 May 2025 passed by the chairman of the corporation. Next,
this is disputed by the petitioner.
Commissioner, passed by the commissioner of corporation.
Same is disputed.
Commissioner of corporation. Ageo dekbe chairman gulo commissioner kore. Next paragraph. Issue whether interference, whether interference to this impugned order dated 20th May 2025 is necessary or not is required to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop affidavit and reply thereto can be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the next available circuit, after the available circuit bench, after the time fixed therein above for exchanging evidence. For hearing. Evidence. All parties are present today.
Well, the corporation also has to file on today.
Yes, obviously. Has to be.
Deeply obliged.
You have to defend your own order. Hey, Shona. Yes, that matter is over.
My lord, item number 13, my lord, I am for the petitioner, but my lord, it is not audible, my lord is not audible, my lord. My lord, no sound is there, my lord. Yes.
I represent state.
My lord,
Item 39 for the School Service Commission.
My lord, it is the extension of recommendation in respect of upper primary
Which
selection
happening for the
process.
school authority.
Yes, yes, my lord. School authority possibly not. My lord, I have
Not
served,
today.
but let it be added, not today, not today.
Not today. All parties are present.
14, my lord, similar issue, my lord, not today.
Not
My
today.
lord, 14, not today.
Not today. Not today. Yes, who is appearing for the respondents? Not today.
My lord, item 8.
My lord, 18 I am for respond number 4.
My lord, one apology, my lord. The arguing advocate Dr. Pavitra.
17.
Sorry, my lord, is one of relative passed away this morning. My lord, kindly fixed it on Monday.
Not this week.
Great.
Fully lodged.
My lord, 18.
18 Nomicon, the not this week follow.
Next. Not today. Go on, colleague. Not today. Not today.
25 for the statement.
Yes, 26. 26. 26. Not today. 27. 28.
28 I am for the petitioner, your lordship. There was a direction to file affidavit in opposition, your lordship. They have not filed the affidavit in opposition yet.
So why it is appearing under the heading motion?
It was,
Please,
it should have ended.
Heading it should have. Hearing matter. This is a mistake with many matters.
If court directs that matter to be treated as motion, then only this can be treated. Otherwise, under the rules, it has to be
Under the heading hearing.
treated as hearing matter.
Your lordship, if your lordship is, part way. Oh.
Issue. On perusal of record, it appears that by order dated 6 March 2025, a coordinate bench directed the parties to exchange affidavits. So writ petition needs to be treated as hearing matter. Next paragraph. List the matter under the heading hearing before the next available circuit, subject to circuit bench, before the next available circuit bench, subject to convenience, or before the next available circuit, subject to convenience of the bench. Subject to convenience of the bench. Yes, what about filing of affidavits? Any issue is there? Have you filed affidavit?
We need.
Why you have not filed affidavit? Very well pay cost.
Yes.
For very well pay cost for making delay in filing affidavit. I am giving you 7 days time and 7,000 rupees to be paid. No, it's very enjoyable thing. After getting an direction for affidavit, not to take any. No. You please, I am extending 7 days time. Then you will face the music. I am extending 7 days time. In the meantime, deposit 7,000 rupees. Pay cost to the petitioner for causing delay. Yes. When this order was passed?
March.
6th of March.
Yes. 2025. And what was the direction for within which time it was required to be filed? Everything is taken for granted. Yes. Yes, then
Kindly.
pay cost.
Generally, it doesn't
Assistant
happen.
Commissioner, State Tax Bureau,
It doesn't happen.
he imposes fine, penalty, everything. So very
Well,
well.
we have not
Yes.
covered. Well, we have
Let the
covered
court,
everything.
let the court imposes one, then he will face the music.
He should take-
Somehow get an order for direction to file affidavits, and we are relieved for at least for 6 months or 1 year or
That
2
doesn't
years.
happen.
No. Why you have not filed affidavit?
My lord, kindly grant 2 days, my lord. By Monday, we'll file it.
Why, if it is
Kindly,
not
ma'am.
filed for last 3 months,
My lord,
then why 2 days time? Very well,
instruction
for
came
2 days
belated, my
pay
lord.
20,000 rupees.
Instruction came lately, my lord. Kindly, my lord. Kindly, my lord.
Let and one exceptional order be passed
Yes, my lord, yes. My lord,
to
that-
send a message to the department.
My lord, kindly.
It's not the
Yes.
first-
Not the fault, my lord, of the department.
They do not spare us, my lords. No, we have not. They have never spared us. It's a state exchequer's money.
It is very nice to impose penalty tax.
Yes, yes,
everything.
we enjoy that. So this is not something we should also.
No.
This is not something that they should face. We take pleasure in doing, my lord. Only when there is a tax evasion, then only the penalty. In case of no evasion,
Sure.
we do not.
Mr. Mominur Rahman, learned advocate representing the state GST authority.
Yes, ma'am.
State GST authority has prayed for 2 days time to file affidavit in opposition. As a last chance, time to file affidavit in opposition stands extended by Monday next, 28 July 2025. Affidavit in reply to be filed by 7 days thereafter. Stop. Time fixed for filing affidavit is peremptory.
I'm great.
Bibliobliged.
থাকছি Not today. All parties are not present.
29, my lord, I am for the petitioner.
Not today. Yes. Yes.
I for this.
Not today.
There is a direction to file report.
Not today. Go on calling.
I am for the petition.
My lord, in this matter, I am appearing with my learned friend, Mr. Paul.
All parties are present.
My lord.
30.
There are other.
32. All
Hello.
parties are present.
Yes.
Find it out. Mr. Pal, find it out.
Additional registered trade union. Well, already here.
Trade union is also represented. Registered.
Labor department, mother.
Is it a hearing matter?
No, mother. It was dismissed for default. On the last occasion, it was restored.
My lord, it is required to be heard by exchange of affidavit, my lord. What is their claim? The registration of the trade union, my lord?
You are for the state.
My lord.
Mr. Chaudhary, you are for the state.
Yes, my lord, yes.
Why you have not come to court today?
My lord, I know that this adjournment and the series of adjournment would be there. And my lord, my office, lordship is such a hot and the
Petition of 2025, they dismissed for default, then it was restored.
Restored.
Is there any scope for passing any interim order?
My lord, actually, we want this trade union registration only, my lord. This is organization form for the tea workers, my lord. And we are waiting for this registration since long, my lord. And they have rejected my
Whether-
application by the registrar after the order of the Honorable High Court, my lord.
my lord, your lordship see 4th October 2024 order.
57, my lord. 58 onwards, my lord. They have rejected my application arbitrarily, my lord, stating that some of the members of the tea workers are not the member of the tea garden. And they have obtained
Page.
page 60,
this rejects, last order is from 58 onwards, my lord. I came to the honorable court, my lord, after not registering the trade union, my lord, in time, my lord. As per the West Bengal Public Services Act, my lord, that had to be done within the 42 days, my lord. But they didn't do that. That I came before the honorable court, my lord. Honorable court was pleased to.
No, where is the illegality in this order?
No, this is okay, my lord, but
This order dated 29 November 2024 denying your registration. By the order passed by the Registrar of Trade Unions West Bengal.
my lord.
Where's the illegality?
No, they didn't give us this opportunity to produce our documents, my lord. They have arbitrarily rejected my application after receiving the order of the honorable court, my lord.
Honorable court
Directed to register the thing and
whether court directed to grant opportunity of hearing to you.
No, it was not there, my lord, but
Where is the order of the court?
58.
4th October 24, Lordship, as I said. My lord, kindly see paragraph 7, my lord.
Of which order? Court's order?
4th October, yes, my lord.
Page 59.
Then, my lord, paragraph 10.
Just a minute.
Sorry.
Either 10% or 100, whichever is less.
Either 7%.
So that has not been complied with.
Yes, my lord. If your lordship see the order of at page 61, an elaborate order we have passed, my lord.
My lord, kindly see that.
So is it a case that the 10% or of the workmen are not there
actually
with your union?
There are more than that, my lord. Please read this paragraph, this page number 60, 11, my lord. Direction to the from the court, my lord.
Paragraph
11, page 60, 11.
Yes, we have disposed of. We have acted upon.
No, paragraph 11 says, Mr. Chaudhary, that the Registrar of Trade Union shall intimate the petitioner with regard to any document that is lacking, so that the application for registration can be disposed of finally strictly in accordance with the Trade Unions Act 1926.
Yes, my lord.
So where is the intimation made by the Registrar of Trade Union seeking certain documents in
But that is there, my lord.
order to comply the first proviso?
Yes, my lord, that is there. That intimation was given to them.
Where is that intimation?
My lord.
Where is that intimation? Where is that intimation?
My lord, if your lordship see, my lord, the page 61, the order, my lord, ordering portion, my lord. My lord, lordship, kindly turn down page 61.
Yes.
My lord, kindly see an application of registration of such and such name was amended, such and such was received. The said application was incomplete. Lordship got it? Incomplete. And the number of
now today, if the petitioners are in position to satisfy the conditions as contained in the first proviso.
Yes, my lord.
Then that can be reconsidered. Issue can be
reconsidered. They could not, my lord. Kindly read the entire order, my lord. They could not. We have explained the elaborately, my lord.
No, my lord. After the order of the court, my lord, they directly verify the documents from the different source, as including the this opposite of this our trade union. Then they have stated that some of the member are from their trade union. some are not the workers that I'm submitting the documents that they are not the tea workers, but we have got the certificate issued by the same management that they are the workers working in the same tea garden, sir.
Not in different.
Not in the different.
And they are the members of your
organizer. And there it is not necessary that all the members should be permanent member. There should be retired member. There can be the member of temporary work, these workers who is working in the tea gardens, Miller. And they have stated that our this total number 100 is not fulfilled by our association because there are some members who are not the member of our trade union. This content is that, and they didn't comply the order of this honorable court of para 11 Miller. They didn't inform that you are not the member of these. Kindly submit these documents. They never stated that.
Miller, one by one paragraph shall I read, Miller?
Trade Unions Act 1926.
Miller, page 61, the second paragraph. Section 4, subclause 1.
4 to 6.
Miller, the appeal provision, kindly see 11 AA. If they are aggrieved, they can prefer an appeal.
But that point was not taken at the threshold.
Miller, this is the first time matter is taken. The first day, Miller.
It's an appellable order.
Yes, Miller. You'll kindly see the 11 subclause 1 AA, small AA. That is the tribunal is the having jurisdiction, Miller, industrial tribunal.
But High Court have also the jurisdiction in this respect first.
Alternative efficacy.
Just a minute. Just a minute.
Lordship.
Is this an appeal provision?
No, they have stated that I can approach to the tribunal, Milord. But I had come before the honorable court as per the order of the honorable court, Milord.
No.
I was
As per order of the honorable court.
that case number 58 onwards, Milord.
There is an order whereby the register was directed to take a decision.
Milord.
If you suffer that decision, then it has to be challenged before the tribunal.
But
Labor tribunal.
No, but there are a provision. Many people had come before the honorable court, Milord. There are I can cite the judgment also, Milord. I can cite the judgment
many
also.
people. Milord, your lordship has decided even 2013.
Milord,
as remedy. What you are handing
over
over
to my case only, Milord.
Mr. Khati, please hand over a copy to Mr. Paul.
Just wait, I'll have to read out.
Is a reported order, judgment?
No, this is judgment of the Madras High Court,
Madras,
2758 of 2019.
This is a judgment yesterday I considered,
Milord.
2013.
2010 SCC, my lord.
And this is organization for the poor workers, Milord. And to have this trade union registration is their fundamental rights, Milord. Similar to my case.
Issue. Matter is heard in presence of the learned experts representing the petitioner Samiti and state respondents. Stop. Next, in the writ petition, order dated 29 November 2024, passed by Register of Trade Unions West Bengal, has been questioned or is questioned, whereby prayer of the petitioner society for having registration was turned down. Stop. Placing reliance upon the order passed by a coordinate bench on a writ petition being WPA 2035 of 2024, dated 4th October 2024. It is submitted by the learned advocate representing the petitioner Samiti. Petitioner Samiti. That the Register of Trade Union ought to have intimated the petitioner intimate the petitioner for production of document in support of their case or in support of its case in order to comply the relevant provisions of the Trade Union Act Trade Union Act 1926, which would have which could lead the register to pass a different order. Stop. Next paragraph. However, during course of hearing, Mr. Chaudhary learned additional advocate general has brought it to the notice of this court. Section 11 of Trade Unions Act 1926, providing appeal provision, which requires petitioner to question the impugned decision dated 29 November 2024 passed by the Registrar of Trade Unions by approaching the appellate authority as contemplated under section 11. Stop. Next paragraph. However, it is submitted by the learned advocate representing the petitioner Samiti that his case is fortified by the judgment dated 10 December 2019 passed by a coordinate bench of Madras High Court. Past in civil miscellaneous appeal number 2758 of 2019. Next paragraph. Next paragraph. It is strike law that when there is an alternative efficacious speedy remedy available, writ court ought not entertain writ petition in exercise of power under Article 26. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2013-10 SCC. Page 2013-10 SCC 83. Within bracket, General Manager, Sri Siddheshwara Cooperative Bank Limited and another versus Iqbal and others. Next paragraph. Hence, writ petition stands dismissed since same is not entertained at this stage. However, this order shall not preclude the petitioner to prefer appeal under section 11. Now, to prefer appeal under section 11 of the Trade Unions Act 1926. Stop. Urgent Xerox appeal.
Before the tribunal. Before the tribunal, Milord.
Next one.
Milord, they are poor workers, Milord. They cannot afford. They get 250 rupees. There are judgment also.
So why the trade union is required? You are sufficient to.
Yeah.
Yes, yes, next matter. Item number 32 already.
Kumar Mondal is appearing for matter of university.
Not today. Next.
Can it be fixed on Monday?
Next.
34.
30.
Next.
34, I am for the petition.
35, Your Lordship, I am appearing for the petition.
Back on the next date.
Yes.
35
Lordship, I am appearing for the
34, I am for the
central
petition, my lord.
Yes,
Respondent number 6.
35, I am for the respondent number 9, my lord. They have
Five.
filed an affidavit opposition. I need to
34,
file a
35.
reply to that, my lord.
Oh, there's a
Lordship,
direction
I
for
appear
filing
on
a
behalf of-
My lord, we have challenged the maintainability of this. They have filed an opposition to that. We need to give a reply.
Lordship, may I make my submission, Your Lordship, with regard to
Come back
item
on the
number
next
30.
date.
Lordship,
Sorry.
Lordship kindly hears their, Lordship kindly passes direction, whoever wants to file their affidavits, Your Lordship. Lordship, let them complete that, Your Lordship keeps it in the next circuit. Lordship kindly allows them to file their affidavit, but Lordship kindly gives a time bound.
Come
This
back
is-
tomorrow, Miss Ghosh.
No, my lord, she's the
Lordship, tomorrow,
petitioner, my lord,
tomorrow.
same matter.
Oh, in this matter, you are for the petitioner.
Yes, my
Lordship,
lord.
I'm for the petition.
I am under the impression that in the previous matter you are appearing.
Lordship, item 35, I'm
35.
appealing for the petitioner.
I am
I'm
the 35.
only,
35.
This is
since all the parties are today, we are under a resolution of not to pass adverse order. Lordship,
Yes.
I'm praying for any specific orders. I'm only trying to indicate, Your
File a
Lordship,
reply to that.
this
The only
matter.
option which is left, either appear or don't appear. If you appear, then I will pass order accordingly. If you
Lordship,
don't appear, then I will adjourn the matter.
Lordship, we are
It is up
Lordship,
to you.
kindly
You are
give out
you have
adjourn,
to
Your
follow
Lordship.
your own resolution. The court has no
I
hesitation
bow
so
down to
far
that.
taking up this matters.
Lordship, I bow down to that. Lordship,
Yes.
since the other respondents are there,
Where is the
Lordship-
direction for affidavit?
My lord, we had filed an CAN application, my lord. On the
Lordship,
previous day,
let
there
my
was a-
learned
they had-
friend already has the privilege of appearing in physically there. Let me also take the privilege of appearing online. Lordship, on the first date when the matter was taken up, Lordship, there at that point of time, Your
Is there
Lordship,
any direction for
Yes, yes,
affidavit
my lord.
in connection with the application?
CAN application.
CAN application, not in.
They have
connection-
filed an opposition, my lord.
Not
We have
in-
filed-
not
we
in
have
the
filed
writ
the
petition.
Even in the writ petition, there was, my lord, but
Where is that?
first order, my lord.
Lordship,
It
first
was
order
to
is
file.
12th
But my
March
lord, since we have filed a
2025.
CAN application,
March.
subsequently, my lord, the CAN is.
12th March 2025.
12th March 2025, Lordship. That order being passed by Honorable Justice Joy Sengupta. Lordship, may I only indicate this much? Since my learned friend, I feel my learned friend will definitely have his chance before this Honorable Court. Lordship, what has happened, Your Lordship? We are challenging
the issue of the certain certificates, Your Lordship, now the difficulty is that during pendency of the writ petition, they chose not to appear. And the WBPCB has taken the initiative to
Yes,
issue
okay.
consent to operate. Lordship,
While
now they're
Lordship,
taking-
I appear.
While
Lordship, in this matter-
Lordship, on every date, they are taking time to file an affidavit.
March 2025.
Lordship, thereafter matter was again taken up on April.
Stop. Writ petition needs to be treated as hearing matter.
My lord.
List the
Lordship,
matter
if I may
under
kindly
under
indicate-
the heading, list the matter under the heading hearing before the next available circuit.
Lordship, if I may kindly
But
indicate
we are
in this
telling
matter,
you only
my
make
affidavit
one
in
month
opposition is
period.
already on record.
Next, whether the affidavits are complete?
Yes, in
Lordship
case-
kindly
indicate in
fixes
this
a
matter,
date by.
Lordship.
Lordship, in case of the CAN one, the application filed by them, we have filed our objection. Lordship.
We will need to file it.
Affidavit in opposition to the writ petition. Affidavit, respondent number 6 has filed. Learned advocate representing respondent number 6 has filed affidavit in opposition to the writ petition today, and same is taken on record to the writ petition.
Lordship, in this matter, Lordship, I appear for the central.
Parties shall
Control
also be
Board,
at
Lordship.
liberty to exchange their pleadings in connection with the pending application or
Application.
in connection with the application being can
Lordship,
1 of
in this
2025.
matter,
Next
Lordship,
matter.
if I may kindly
Lordship
indicate.
kindly fixes a day, Lordship kindly gives a time out for exchange of affidavits. This is my only. Lordship, grateful, my lord.
All parties are present?
There is a 5
Not today. Not today. Next.
I am for the respondent 37.
Come back on the next day. Yes, next. Not today. Not today.
41 is for the bank.
Not today. Not today. Not today.
Yes, I am for the respondent 45.
Come back on the next day. Next.
45.
Next day.
For the petitioner, my lord.
Yes, next.
40.
Come back on the next day.
Report must be submitted. My lord,
Yes.
only report to be submitted, my lord. Affidavit to be
Lordships,
submitted.
I appear, Lordships, I beg to appear in serial number 47 to 57. Lordships, I beg to appear.
Have to 50, only reports to be submitted, my lord.
Come back on the next day. Yes.
Lordships, I beg to appear in serial number 47 to 57, Lordships.
For 47, yes.
Lordships, I beg to Lordships, am I audible, Lordships?
Yes.
Lordships, serial 47 to 57, I beg to appear on behalf of the petitioners, Lordships. May I place my case, Lordships?
No, other side is not there, not today.
yes,
Next.
sir.
Lordship, other side is there, Lord.
Oh, very well. Yes, all parties are present.
Lordships, I am representing the petitioner. It's a batch
Why
petition.
the group matters?
Lordship, I will explain, Lordship. Serial 47 is the matter and
Only-
all are
Hearing matter or motion?
There was a direction to file
Lordship, it's a motion
report.
matter.
My lord.
Lordship, it's a motion matter, Lordship. May I submit, Lordships, once?
Very well.
Report का report दीजिए ना हर फाइल में. Lordship, may I submit?
The report matter, Lordship.
Yes, similar to this.
छोटे ही इसका.
Who is for the state?
We are for the state, my lord. State.
Lordship, it is
You are for the
CGST.
central organization.
CGST.
Who is appearing for the state?
Lordship, it is CGST. State is not there in the matter, Lordships.
But it is recorded in the previous order, 9 July 2025.
So,
The land advocate appearing for the state respondent.
so that the order is being, we have rectified the order.
Dilip Kumar Agarwal,
Rectified किया ना, state हो गया था कल.
Ratan Barik, and Vishwaraj Agarwal for the respondents.
Yes. My lord,
And the Dilip Kumar Agarwal, Vishwaraj Agarwal.
I am representing.
So today you are filing reports.
Yes,
Yes,
File a report.
yes, reporting.
Very well, give a reply to this report.
Lordship, there is no requirement of giving a reply,
No,
Lordship.
come back with a reply. Yes, yes.
Lordship, I kindly note, Lordships, Lordship, I am greatly in prejudice, Lordship. There is a huge prejudice cause, Lordships.
Yes. In terms of the previous order, a report is filed on behalf of CGST authority and same is taken on record. Next paragraph. Leave is granted to the learned advocate, leave is granted to the petitioners, learned advocate for the petitioners to file an exception to this report by 7 days from date. Stop. List the matter before the next available circuit for further consideration. Under the heading hearing.
Lordship is not a hearing, Lordship. Lordship, may kindly record my submission that I don't want to file an exception. May kindly record, Lordships. Lordship, may kindly record that. Lordship, it's a motion.
You are appearing for?
Lordship, for all the petitioners, serial 47 to 57. Lordship, may kindly not record, otherwise, Lordship, it is let it be kept under motion only because it is not a direction of affidavit, Lordship. Lordship, I will, if your Lordship's next circuit, I'm okay, Lordship, no problems with the next circuit order, Lordship, but not because, Lordship, it's not a hearing matter, Lordships. I beg to state that, Lordships.
Very well. Whether copy has been given to him?
Yes.
Yes. What is the matter about?
Lordships, in GST, the refund, section 54 of the CGST Act is the entire procedure which deals with the process of refund. Now, Lordship, the law envisages two processes in which I can get a refund. One is to an exporter of goods who export goods to third countries, to other countries. That exporter is entitled to refund of accumulated input tax credit. So, Lordship, there is a concept of input tax credit under the GST laws, Lordships. Whatever I purchase, I am a trader, Lordships. When I purchase it from a third party, I pay GST to my supplier. That is my input tax credit. If I sell that goods locally, I pay output GST, which is against which my input is offset. But if I export the goods as per the provisions of the law, then I did not pay any output GST. It is called as zero rated supply, Lordships, under section 16 of the IGST Act. Now, Lordships, the law envisages under section 54 subsection 3 that an exporter of goods,
while a report was called for.
Lordships, I will submit, Lordships. May I submit, Lordships?
Yeah, wait. Why report was called for?
Lordship, we have said these three are the pan masala.
Again pan masala?
Yes, same. And all are nearby and we are having the.
Yesterday I had to dispose of one matter.
Yeah, and all are the pan masala.
All are pan masala walas.
Only why we have rejected their claim, we are saying you just show us the export document, Bhutan document.
Oh, that's similar issue.
Similar. So they are saying in the law there is nothing that you cannot ask. So, but in the law itself says that whenever any proper officer sanction the refund.
Now, whether in this case refund has been allowed?
No, Lordships.
Refund was rejected.
On the only ground that I have not furnishing, Lordships, may I submit, Lordships, 1 minute. Lordship, on the ground that I am not submitting Bhutan custom declaration.
Only that
declaration.
Because
so have you do you have the occasion to whether you had the occasion to consider that document?
Yes, yes.
By the authority while rejecting the refund.
No, Lordship,
that
the
also
only
struck me yesterday night that let there be an adjudication by the authority with regard to the document which the petitioners are relying upon.
Lordships, in my case, Lordships, may I submit, Lordships?
Court will embark upon this at the first instance.
Lordship, may kindly give me 1 minute to explain, Lordship. I'll take 2 minutes of your Lordship.
Wait, Mr. Counsel, please wait. Why
Lordship,
court will embark upon this? Whether while rejecting, I am asking you one thing. You obtain an instruction, come back. Because I am asking you that my query is this, that a document is being produced by the petitioners in support of their claim of refund. That document you are disputing. Not you are disputing, being an advocate of the CGST authority. That document you are disputing, but because according to this is not the nature of document which is to be taken care which is to, please hear this court. Have the patience to hear the court first. Now, this is not the nature of document which is required to be considered because there is a different pattern of document which ought to be given credence. Now, this is your submission so far yesterday's matter.
Yes, But
Now, in this matter also, you are saying that similar nature of document is being relied on. They have not. Please don't nod your head, shake your head in this fashion.
What I'm saying.
Now the position is this. Have you gone into considered this document by any authority?
They have not filed. We have asked for the export document. They have not produced. But as per that.
So let it be produced and let it be decided by the authority.
No, they are disputing that. That's why the petitioner is disputing that we cannot demand that document. That is their point of view. Because as per the act, whatever the document is required for the refund, they have submitted. But my proper officer, while verification is come to the knowledge as per the SEC reports, that these two things, cigarette and pan masala, is being which being exported to Bhutan. It is being dumped in the
Same thing, I know that story.
But they
Please tell me whether the document has been considered by your authority or not.
They have not submitted.
So let them submit this document. I am permitting them to submit a document considered.
That is the break.
Yes, Mr. Advocate, you submit the document which you are relying upon in support of your claim of refund, and that is to be considered by the authority.
Lordships, may I just say 1 minute?
Because if it is a case of export, and if it exits, if the consignment exits the border of India and enters into Bhutan, in that event you are entitled to get a refund.
Lordships, may I submit?
Now, in order to substantiate your case that consignment has crossed the border, there is a document which you are relying upon, which the authority is not agreeable to accept that document.
No, Lordship. Well, Lordship, 1 second. Just 1 minute can I interfere? Lordship, the department says I have submitted all valid proofs of export. Now they are asking to submit a third party, which the importer in Bhutan submits to Kingdom of Bhutan. They are asking me to produce that document, which is not under my control. In the entire adjudication order, Lordships, they say, yes, your documents are genuine. Lordship, as per section 14 of the Customs Act, the LEO copy of the shipping bill is a proof of export. The let export order which bears the customs stamp and seal. I have produced all documents. They have not disputed it. Now, because they say in the show cause as well as in the report that there is a cartel going on in that region, therefore, we are asking you to submit the document submitted by importer to the Kingdom of Bhutan. Lordship,
now, in support of your exit, support of exit of consignment, which document you have produced?
Lordship, I have produced the let export copy of the shipping bill.
Where is that document? Where is that document?
Lordship, may kindly take page 28 in the serial number 47 your Lordships is having. Page 28 onwards also, and page 31 is the first LEO copy, let export order copy, which is the document of goods being exited from the territory of India as per section 14 and 16.
Where from it can be inferred that based on page 28 it can be
31, Lordship, page 31. Page 31, Lordships.
Yes, page 31.
Page 31, Lordship, may kindly see Indian Custom EDI system. This yes. And this is given LU let export order copy. Let export copy it is given. So this copy is only generated by the customs authority, not by me. Once the goods are exiting from the territorial jurisdiction of India, then only this can be generated through the EDI system of the customs, and customs authority gives this to me. I cannot generate this.
Whether any formal order has been passed rejecting their claim of...
Yes, Lordships, they have rejected my claim on the ground that I have not submitted Bhutan custom declaration which the importer needs to file through Kingdom
because
of Bhutan.
There is a racket going on. After entering into this area of 3 kilometers, the consignment is being diverted to somewhere else.
Lordships, I bow down to that, Lordship.
Not reaching Bhutan.
I bow down to that, Lordship. If that had been the case, then this LEO copy could not have been produced by me. And they say, yes, it is a valid LEO copy. They are casting impression on the customs department.
Who is appearing for the customs authority?
Lordship, there is no customs department because, Lordship, I am aggrieved.
Then array customs department.
Lordship, kindly give me 1 minute, Lordship. Lordship,
no.
Lordship, this is not. Lordship, kindly hear me for 1 minute.
No. And a blind, without considering the view of the custom, this issue cannot be gone into.
Lordship, but that is not an issue, Lordship. The issue which the adjudication order says is that I have not produced.
A report is, কেটে দাও আগের orderটা. The report is filed in terms of the previous order by the CGST authority and same is taken on record. Next paragraph. Petitioner is claiming or petitioners করো একসঙ্গে সবকটা order করে দাও. Petitioners are claiming refund based on a document which is based on a document called Indian Customs EDI system issued by the concerned customs authority.
LCS Jagao, it is written, Lordship, in top left side.
According to the petitioners, such Indian Customs EDI system document is a conclusive proof that consignment has been exported to Bhutan. Stop. On next paragraph, on the contrary, learned advocate representing the respondents, representing CGST authority has disputed such submission based on a fact that after customs clearance, consignments are being diverted to other parts of India and in effect goods are not being exported to Bhutan.
We have given the report of.
But the refund is claimed by the exporters. But the refund is claimed by the petitioners being exporters. Stop. Next paragraph. Having considered the submissions made on behalf of the petitioner, this court finds it apt to direct the petitioner to add customs authorities as additional respondents in the writ petitions, which would facilitate this court to come to a conclusion whether at all goods were exported to Bhutan or not. Next paragraph. Leave is granted to the learned advocate representing the petitioners to amend the writ petitions by 23rd July, by 30th July 2025, and add customs authorities as additional respondents. Stop. After such amendments are carried out in all the writ petitions, learned advocate for the petitioners is directed to serve copy of the writ petition. Is directed to serve copies of the writ petitions, copies of amended writ petitions, and copies of amended writ petitions and the order passed today upon the additional respondents by fortnight thereafter, and file affidavits of service in connection with all the writ petitions on the next date. Next paragraph. List the matters under the heading methods before the next available circuit bench.
Lordship, instead of fortnight, I will do it in 1 week, Lordship.
Next matter.
My lord. My lord, in item number 51 to 57, my lord, I am appearing in item same submission.
Lordships will take care.
Lordships, I kept it under motion, Lordships.
নেমে গেল নাকি? Grateful. চল।
একটা লাইনে অ্যাড করে নাও তো ওই ম্যাটারটা। ওখানে যে সাবমিশনটা পিটিশনার অ্যাডভোকেটের রেকর্ড করলাম গ্রুপ ম্যাটার্সটা, একটাই তো কমন অর্ডার হবে। At a line at corner, it is submitted by the learned advocate representing the petitioners that petitioners are not willing to file exception to the report filed on behalf of CGST or others. Call the next matter. Not today.
I am for the petition. Your school service commission is answering this.
Not today.
My lordship. So I am for the petition.
Not
Your
today.
Lordship, I am appearing.
I am to the petitioner, my lord.
Not today. Sixty-two.
Lordship, I am a petitioner in person in this case. Lordship, the petition is filed due to infringement of my legal right to solemnly affirm for some important affidavits required to be filed under section 173(4) of BNSS. Because I am agreed by
Please for the other side.
the state.
Where is all parties are present?
But only state is there.
Only state is the.
There is a prayer in the petition.
There is a page. Page 9. I have paid for it. Issuing a direction, written direction, to the concerned authority of the state to enforce my legal right to solemnly affirm.
Yes. Yes. Make use of.
My lord, it was.
What
actually-
affidavit you want to affirm?
Affidavit regarding filing an application to the superintendent of police under new BNSS 175 of 175(3) of BNSS. It
Hey, DNS.
matches. I'm gonna check copy. I have a copy.
Just on. Very careful. Yes, what is your grievance?
My grievance is that the concerned authorities who are
Which authorities?
The authorities who can allow me.
Which authorities?
The authorities who are competent to allow a deponent to
What
surrender.
those authorities?
Those are the London district judge, any judicial magistrates or executive magistrates, the oath commissioners, and also the notary public. They are the competent authorities under section 333 of BNSS, my lord. Section 333 of BNSS empowers these authorities to allow a deponent to solemnly affirm. Section 333 of BNSS, my lord.
That is relating to examination of witnesses.
Which section, madam?
Triple three.
Triple C of BNSS.
Yes.
Triple C of BNSS is about
Authorities
before whom
affidavit
affidavits
be
may be
sworn.
sworn. Yes.
Yes.
Any
That
affidavit.
is relating to examination of witnesses come to subsection 2.
No. Any affidavit. Any
What? No.
supporting affidavit.
You are before the court. You should know how to address the court.
Sorry, Malad, but it is.
Since you are appearing in person, you cannot make submissions in a way you want. Come to subsection 2 of 333.
Subsection 2 of Triple C. Affidavit shall be confined to such facts as deponent able to prove.
Affidavit shall be confined to, comma, and shall state separately such facts as the deponent is liable to prove from his own knowledge. Now come to heading B before section 319.
319 is
yes.
available with me. 319 is.
Commissions for the examination of witnesses. So for what purpose you want to file an affidavit, affirm an affidavit? That is what court is asking you.
To comply section 170, 173(4), BNSS and 173(4) BNSS. In 173(4), my lord, you won't find that there is any direction for filing with affidavit, but 175(3) will confirm it.
Whether your information has not been considered by the police authority.
Yes, police authority.
What information you wanted to divert?
No, I have informed under section 173(1) information of cognizable offences.
What offense? How you are affected? Being the de facto complainant.
Affected due to excess charge of court fees, my lord. Actually, the prescribed court fees beyond excess, beyond the prescribed charges has been being taken by the concerned authorities, specifically the.
So that has to be first satisfied. Whether the court fee has been charged in excess or not, it has to be first determined. Then question of instituting the criminal proceeding will arise.
Yeah, no, I have produced them material documents. The IO has taken all the relevant documents. I have submitted under court 170.
The parties necessary for this disposal of this petition are not being added. The notary public whom he alleged that he
Court
has.
fees in connection with what?
Court fees for certified copies, of orders.
Which orders? How you are associated with those orders?
I have filed cases in the district court, and while receiving.
That has to be specifically stated in the writ petition. That which orders where this court fee has been charged in excess, that has to be narrated in the writ petition.
No, these are.
Where is the case made out?
These are less relevant, Malan. These
are relevant. Where is the case made out?
These are connected to the main complaint filed to the police concerned authority under certain.
Otherwise, I have to dismiss your writ petition. Instead, due to lack of facts.
I have given some brief, at least some.
No. A specific case has to be made out that where by which authority excess court fee has been charged. Where you have stated, in which paragraph?
No, that is a part of the complaint made to the police.
No, in the writ petition where you have stated.
The writ petition is pertains to allowing me to.
But that based on your allegation is that an excess court fee has been charged.
No, that is the depend.
By which authority?
I am submitting an application to the.
I am asking you by which authority excess court fee has been charged.
Where you have one authority is.
Have you stated in the writ petition?
No, that is not the issue of that. That is
the case has to be made out. Otherwise, this the writ petition, how you are affected, that has to be narrated. And that has to be
That
demonstrated.
is subsequent issue. That is that will be decided by
If
the.
it is a
court.
subsequent issue, then how they previously.
The
this
primary issue is
then
that
the
whether
petition,
whether the
writ
competent
petition is
authority
premature.
whether the competent authority can deny me to solemnly affirm. This is the main issue.
But the purpose has to be narrated.
The purpose is that I filed a complaint to the police. If police didn't take action, due to police inaction, I have to approach the superintendent of police. Now, to file application to the superintendent of police, there is a mandate under BNSS that it
Don't make any submission in the air. If you have made out a case, please point it out before this.
I am making clear submission, my lord.
No,
175 of BNS.
Making submission without any averments in the writ petition will not do.
The amendments I made regarding, I'm telling you, my lord, can you see then annexure? Annexure P4, my lord. I made a representation to the learned district magistrate.
So your case is based on 173(4). Issue. It is submitted by the petitioner appears in person and has submitted that he should be permitted to affirm affidavit. Under section 333 of Bharatiya Nagarik Suraksha Samhita 2023. Stop. Such submission is made in connection with such submission is made no, stop. It is also submitted that the case which has been made out in this writ petition also attracts provisions under section 173 within bracket 4 of BNSS. Stop. Stop. Having considered the provisions under section 173 within bracket 4, court has made a query to the petitioner whether the complaint whether the petitioner is aggrieved by a refusal on the part of officer in charge of a police station to record the information or no. Stop. It is submitted that yes, petitioner intended to bring it to the notice of the concerned police authority that excess court fee is being charged for which a criminal proceeding is required to be initiated. Stop. However, how excess court fee, next paragraph. However, how excess court fee is being charged and by whom such however, how excess court fee has been charged and to what extent that is not stipulated in the writ. neither who has charged excess court fee is also not disclosed. Next time. In view of now, in absence of necessary details, issue cannot be dealt with. Hence, writ petition stands dismissed. Next. Next.
I have made for the petition, in this case, the state was to submit a report.
Not today.
Report.
Lordship, I am appealing for the petition. This is the matter, my lord, where
Who is appearing for the respondents? Not today. Next. I beg to appear on behalf. Not today. Next.
What's it, there is the direction of filing the affidavit.
My lord,
Yeah,
in
next
item
in-
number
in-
66,
in
I am
presence of-
appealing for the petitioner, my lord.
Yes.
My lord, this matter relates to, my lord, the illegal detention of Erica nuts, my lord, which is a perishable item by the GST authorities, my lord.
Now, this cannot appear under the heading hearing as your learned advocate, as your learned friend appearing for the authorities as submitting. There's a direction for filing affidavit.
My lord, that direction, if your lordship looks to the order, on 10th June, my lord, they had appeared before the available circuit bench and prayed for 1 week time, my
They will
lord.
not today, come back tomorrow. Next.
My lord, that is why I am praying, my lord. If your
Not this
lordship
week,
permits
not
me.
this week, next
No,
matter.
my lord, no, my lord. No, my lord, kindly, my lord, my lord. What I am seeking is, my lord, if you're, because this is a perishable item, my lord, tomorrow I will come before your lordship physically to address you, my lord. If some priority can be given, my lord.
No, sorry. It's an hearing matter, no priority to be given.
No, my lord, I'll be praying for interim order because, my lord, the goods in question at Erica Nat, those will perish, my lord.
File
Those
the-
are detained from 25th, my lord.
There's a direction for affidavit.
Yes, and filing the reply also.
My lord, that direction was on 10th June, my lord. They
There is
have
the-
they sought for a 7 days time. That is why I am praying, my lord.
As per the direction of the division bench. Lordship, move to the division bench.
My lord, the proceedings that has been carried on by them from the very inception is without jurisdiction and against the GST Act, my lord. My lord, that is why I am praying, my lord, if your lordship can give me some priority, tomorrow I'll be before your lordship physically, my lord, to address, my lord. And the only reason I'm doing so, my lord, because the goods are Erica nuts, those will perish, my lord. Kindly, my lord, give me that opportunity, my lord.
Issue. On perusal of records, it appears that Honorable Division Bench video order dated 19th May 2025 was passed on an intra-court appeal being MAT 39 on 39/2025. MAT 39 of 2025 granted liberty to exchange affidavits in the connected writ petition. Stop. Affidavits are complete.
After that, there is one order of the
Yes, my
earlier
lord, of 10th June.
Order passed by the division bench.
this coordinate bench, after the division bench, the matter is taken up and the earlier bench given the direction.
My lord, the order was passed by Honorable Justice Gaurang Kant, my lord.
Yes.
Yes, whether the affidavit is complete.
Yes, sir.
Highly.
Yes.
What about reply?
They are submitting it today, my lord. On 10th June, they sought for a 7 days time. They are filing it today.
Today is
That
the
has not
first
been
day.
served upon us.
Yes.
My lord, may only pray this, my lord, kindly keeps this tomorrow.
Correction, writ petition, stop. Next paragraph. Learned advocate representing CGST authority has filed an affidavit in opposition today and same is taken on record. The time to file affidavit and reply stands extended by 2 weeks from date.
My lord, 1 week will require 1 week, my lord.
From date, stop. Very well. By 1
1
week,
week.
from time to file affidavit and reply stands extended by 1 week from date, stop. List the matter before the next available circuit for hearing, subject to convenience of the bench.
My lord, may I only pray for this thing, my lord. My lord, may it be this circuit, my lord, because within 1 week we will be able
Next
to file,
matter.
my lord.
Next matter.
My lord, the only reason, my lord, I was praying because the goods are perishable in nature, my lord. If your
Not
lordship
today.
kindly considers, my lord.
60 time for the petition.
Not today.
Lordship.
You are not be a representing, but it is not representing.
Up to
Up to
71.
72, Lordship.
72.
68 to 72.
72.
Identical matter.
68 to 72. Not this week. Next. Next.
23.
72. For the respondent, but I would not today.
74.
Not today.
75. 76.
76. 76 for the respondent. Not today.
77. 78.
Go on, call it.
78 praying for short Passover.
Not today.
79. 80. 81. 82. 83. 84. 85.
80, 84. Petitioner. Who is other side?
Other side, the School Service Commission, Mr.
Not today.
85. 86. 87. 88.
Petitioner. Not today.
89. 90.
90 Lordship. And for the petition.
Not today.
91.
Sure, I am for the petition. Not today.
92. 93. 94. 95. 96.
I am for the respondent.
Not today.
97. 98. 99. 100. 101. 102.
These adjourned motions are hearing matters. Why it has come under the heading adjourned motions?
There are two matters, my matters, but those were earlier taken up but not considered. So adjournment was.
Was there any direction by this court?
No,
The
no.
matter to appear under the heading?
At least in those two matters, there was no direction. It was adjourned, but not a fresh. Two matters which are my matters. Others, my lord, I cannot.
Who has ascribed this nomenclature that I want? That is prevalent in our original side at the principal bench. In the appellate side, this adjourned motion theory, yes, let me consider it, please.
Item number 103. 104. 105.
No, 105, 106, 107, my lord.
Yes.
These are similar matter, my lord. Your lordship also passed similar order.
Well, the similar order is to be passed in presence of other side.
Yes, your lordship. Can it be fixed, my lord? We mentioned your lordship. No.
That I cannot do. Other
Well, kindly
matters,
see this order.
learned advocates are praying for giving preference. No, 3 matters to be taken up together.
Kindly,
Yes.
please see this.
Yes.
Kindly see this order.
Wait, I know that this para teacher and the Samprosharok, wait for some time. It's not very urgent.
No,
Yes.
not para teacher, my lord.
Then
My lord, nomentia, my lord. No, nomentia, my lord. Kindly see this. order.
nomenclature means?
My lord, kindly see this order.
Please tell me what is the matter about.
Lord, the petitioner before your lordship was supposed to happen in the year 2016, my lord. They have happened
they have appointed in the year 2021, my lord, and in the meantime, your lordship was pleased to pass that in the meantime, the salaries to minister should be given to them. Who is happening for the West Bengal Board of Primary Education and DPSC? Well, like last occasion, it was today whether the DPSC is represented. It can be, my lord, to be mentioned, my lord. How it can be? Next matter. Which district permanent school council? Well, it is, my lord, from Kuchbihan, my lord. Mr. Rai appears. Yes, next matter. 108. Chairman has to take decision. Is for the state perhaps. Yes. Next. 109. Time for the petition. 110. 111. If I upgrade your matter and place it under the heading to be mentioned, then other matters where where learned advocates are praying for preference, those matters are also required to be placed under the same heading. How I can give preference since this is a matter which is covered by my usual order. That is not proper. Please. 112, 113, 114, 115, 116, 117, 118.
If you appear and for the petition.
Not today.
119 also.
Not today. 120, 121, 122, 123, 124, 125 and 126, 127, 128, 129, 130, 131, 132, 133, 134, 135, 136, 137, 138, 139, 140, 141, 142, 143, 144, for I am for the schools. 145, 146, 147, 147.
Lordship,
147, yes.
I am for the petitioner.
Case there is a direction for the opposition. My opposition is ready.
File it.
Lordship, long before this opportunity was given to the respondent. But till this day, it's not.
Today they are filing. देखिए 147 টা দাও only authority is National Highways Authority.
It also. The point number 1 is state.
Acha, issue. Who is appearing for the state? Shubhis Shaha, Hirak Bormon. Yes, Mr. Saha, please come forward. Since matters are being adjourned, especially hearing matters, you are not making any venture to appear before this court. You know the question which would be put forward to you. Yes, why affidavit has not been filed? Whether shall I record it that the state is not willing to file an affidavit? No, if you want, I can record it. Then only the petitioner can file a comprehensive reply dealing with the statements made in the affidavit in oppositions filed by the NHS as well as state. So if you do not file an affidavit in opposition, how Very, very. Matter is taken up for consideration when learned advocate representing National Highways Authority has filed affidavit in opposition and same is taken on paper. Time to file affidavit in opposition by the state respondent stands extended as a last chance for 7 days.
Lordship.
Stop. Petitioner, time to file affidavit and reply also stands extended by 2 weeks thereafter. Stop. Time extended for filing affidavits is peremptory. Stop. Petition, let the matter appear before the next available circuit after the time fixed herein above on extension to file affidavits, comma, for hearing.
Grateful, Lordship.
Next. Not today.
150, there is a direction for the opposition.
Who is for the petitioner? Not today.
151, I'm for the petitioner, your lordship.
Not today.
152, I'm for the petitioner, your lordship.
Not
Then kindly fix this matter on Monday, your lordship.
1449 and 1450.
Oh, 151 and 152, your lordship.
151 and 152, not this week.
Grateful, your lordship.
154. 155. 156.
156, I'm for the petition. My lord, my affidavit in
Please,
reply
please for the other side.
have served, my lord. It could be taken on record.
Not today. Other side, if does not appear, then I cannot take up.
He was here, my lord. He is choosing.
157.
157, I'm appearing for the petitioner, your lordship, a similar matter where the petitioner, for the petitioner, Mr. US Menon was appearing, and for this WB SEDCL, your lordship, Supriya Chattopadhyay, Mr. Chattopadhyay was appearing, and your lordship was kind enough to fix this matter on 30th. So this is another. Grateful, your lordship.
158. 159. 160. 161. My lord, in 161, there was a direction to file affidavit. We are ready with the affidavit.
You are for the respondent state, but who is for the petitioner? Otherwise, I could have recorded an order, passed an order recording that you have filed.